In this chapter, we're going to cover sales contracts, rights, duties, breach, and warranties. So remember, we're still in our section that is governed by the UCC sale of goods. So that is what we are talking about in this chapter. First, we're going to start with the rights and duties of the parties, so the buyer and the seller. The tender of performance must happen. That means you must offer to turn over the goods or offer payment before you have the right to sue on the contract. The seller must make conforming goods available during a reasonable hour of the day. If it's a shipment contract, the seller must put the goods in possession of the carrier and contract for transportation, and the buyer must tender payment in a means and manner commonly used in the ordinary course of business. So even if the buyer knows the seller isn't going to perform, the buyer still must offer to pay before the buyer can sue on the contract. The buyer's rights and duties are as follows. The buyer has the right to inspect the goods prior to payment or acceptance. The buyer could accept all the goods, none of the goods, or accept a commercial unit or units and reject the rest. And a commercial unit is just a division of the goods that makes commercial sense for the buyer. So maybe all of the shirts or something like that. If the buyer rejects the goods, it must be done within a reasonable time after delivery or tender. They have to notify the seller of any defects and take reasonable care of the goods until the seller can remove them. If the seller doesn't instruct the buyer of what to do, the buyer can store the goods for the seller, reship them to the seller, or resell them for the seller. And if the buyer does that, the buyer is owed reimbursement for reasonable expenses. If the buyer is a merchant of the goods, so the buyer sells goods of that kind, the buyer owes a special duty of care over the goods, and they must attempt to sell the goods for the seller if they're perishable or if they decline in value quickly. If the buyer accepts goods, they can't reject the goods. And that would occur after a reasonable opportunity to inspect, and the buyer does one of the following. The buyer signifies that the goods are conforming. They signify a willingness to accept even though they're non-conforming, or they fail to reject them, or they perform an act inconsistent with the seller's ownership. A buyer can revoke acceptance, though, if the goods were accepted on the assumption that any non-conformity would be corrected, and it's not. If that's the case, acceptance can be revoked. If that's going to happen, the buyer must do it within a reasonable time and must notify the seller of revocation. The seller's rights and duties include the following. The seller can cure a defect when time per performance has not yet expired. Cure means fix it, make it right. So if the time for performance hasn't expired and the seller delivers faulty goods, the seller has the right to fix it. If the time for performance has passed, the seller can still cure if the seller believed the goods delivered were acceptable and just found out they weren't. They must notify the buyer of plans to cure, and the seller may only cure when the buyer rejects goods or revokes an acceptance of goods. A breach of contract is, of course, when one party fails to do what is agreed to in the contract. They fail to perform, so they either fail to deliver goods or they fail to pay. An anticipatory breach is one that happens prior to the time of performance. So the seller agrees to sell a number of goods, but before the time that they're supposed to deliver those goods, they let the buyer know that they're unable to perform under the contract. In common law, the person who was harmed by this used to have to wait till the time for performance occurred before they could sue. They don't have to do that anymore under the UCC. The injured party may take action immediately when waiting would be unjust or cause a material inconvenience, and all normal remedies for breach are available here. If the buyer is going to breach, the seller can withhold delivery of goods or stop delivery of goods, so stop them in transit. They could resell the goods, and they can sue for damages. Damages could be measured as the difference between the contract price and the market price, or maybe the profit, and they're also allowed to sue for incidental damages. They could also sue for the price if the goods can't be resold for a reasonable price. This might happen in a situation where the goods are custom goods, or they can cancel the contract. If the seller breaches, the buyer has some remedies. The buyer can cancel the contract. They can sue the seller for the return of any money they've paid. They can cover the sale, which means they can go out and buy the goods elsewhere and then try to recover the difference in the price they had to pay from the seller, or they could recover any other damages from the seller. They can sue the seller for the difference between the agreed price and the market price. And if they accept nonconforming goods, they can notify the seller of the nonconformance, and if no adjustment is made, maybe to the price, they could sue the seller for breach of contract or warranty. If the goods are unique or rare, they can sue for specific performance. But remember, like we talked about before, courts don't really like to enforce specific performance, but only will if the goods are really unique or rare. The statute of limitations is a time limit placed on the right to sue. So under breach of contract cases, if it's a breach of a sales contract, a party generally has 4 years from the date of breach to sue on the contract. After that, they can no longer sue. The parties can agree to a shorter time period in the contract, but usually not less than a year. Now we're going to move on to warranties. And warranties can be express or implied. So an express warranty is an oral or written statement, promise, or other representation about the quality of a product. So a statement of fact or promise, not sales puffery. So this is something that the seller says that is a factual statement. This car can go 100 miles per hour. That's not sales puffery. That's a statement of fact or promise. This would be an express warranty if it was an oral or written statement, promise, or other representation about the quality of the product. If we advertise express warranties, the Federal Trade Commission has some requirements. If I have an ad stating that a product has a warranty, I must disclose how to get a copy of the warranty. If I have an ad using the phrases satisfaction guaranteed, money back guarantee, or free trial offer, I must refund the full price of the product at the purchaser's request. And if I have an ad offering a lifetime warranty, I must disclose any limits on that offer. So if I want that offer only to apply to when the original purchaser owns the product, I need to disclose that. Any descriptions, sales, or models that are shown at the time of the contract become an express warranty if they're part of the basis of the bargain. So if I have a client who is going to buy something and I show them a model, then I am warranting that the product I sell them will be like the model. And then finally, the Magnuson-Moss Warranty Act is going to create or govern express warranties. We'll talk about that on the next slide. So it applies when written warranties are made voluntarily for the purchase of consumer products sold in interstate commerce. Consumer products are tangible personal property, normally used for personal, family, or household purposes. So things I use in my home, they're tangible personal property, meaning not real estate, and also things I can pick up, touch, feel. Interstate commerce means they're sold across state lines. If this act applies, I have to disclose whether I am offering a full or a limited warranty. And a full warranty says that a defective product will be repaired without charge within a reasonable time after a complaint. And then if I can't repair it, I will replace it. A limited warranty is anything other than a full warranty. I can also have implied warranties. So these are warranties that are going to be imposed by law rather than by a statement. I have an implied warranty of merchantability, which says that goods are reasonably fit for the purpose for which they were sold. If I am buying a water hose, it should work, right? I should be able to run water through it and use it in any normal way you would use a water hose. Even though the box that the water hose came in doesn't say that it contains a warranty, it contains that warranty. I can always return it to the manufacturer if it's not working. And that applies when the seller is a merchant. So it's not going to apply if I buy a water hose at a garage sale, right? If I go to a garage sale and I buy a water hose and it's full of leaks, I can't return that. But if I buy a water hose from Home Depot and it's full of leaks, I can return that. There's also an implied warranty of fitness for a particular purpose. This comes into play when a buyer goes to a merchant seller and tells the merchant seller what they want to do with the product and allows the seller to pick the best product for that use. When that happens, when the buyer discloses the purpose of the purchase and the seller selects goods to meet that need, a warranty is created that the goods will be fit for that particular purpose. And if they're not, they can be returned. And then usage of trade. Past dealings or normal dealings in trade can also form the basis of implied warranties. When we sell something, we make a warranty of title. The seller is warranting that they can deliver good title. They're warranting that this is not a stolen product or this isn't a product that has a big lien on it. So we're warranting good title. If I want to exclude any warranties, it must generally be very bold and very conspicuous. So if I want to disclaim the implied warranty of merchantability, I must actually use the word merchantability in the disclaimer. And unlike old common law, privity isn't required. And privity, if you remember, means part of the contract. So party to the contract. You don't have to be party to the contract to be covered under these warranties. And the courts find that extension in one of these three alternatives. First, the seller's warranty extends to any natural person in the family or household of the buyer or a guest in the home if it's reasonable that such person would consume, use, or be affected by the good. The seller's warranty extends to natural persons who may reasonably be expected to consume, use, or be affected by goods and who is injured in person by breach of the warranty. Or the seller's warranty extends to any person who may reasonably consume, use, or be affected by the goods and who's injured by breach of warranty. So this is really going to just extend these warranties to natural users of the goods, which makes sense. If a husband buys a product and the wife is injured by the product, it would be reasonable to assume that the wife would have used the product.